Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about when and how the Canadian Charter of Rights and Freedoms applies outside the borders of our country. Are Canadian officials acting outside of our country constrained by the Charter? Or is there unconstrained action by Canadian officials abroad? The issue was recently considered by the Supreme Court of Canada in the case of McGregor and the Queen. The charity that I work for, the Canadian Constitution Foundation, was an intervener in that case, arguing for a new test on how and when the Charter applies outside the country. The underlying facts of the case are disturbing. They involve sexual assault, voyeurism, hidden cameras, Canada's military, and this question of whether the Canadian Charter applied to the search of the accused, McGregor's, home. Here today to talk about the case and what the CCF has proposed for improving the law are two experts. Joanna Barron is the Executive Director of the Canadian Constitution Foundation, and Jesse Hartery is a lawyer with McCarthy Tétrault who represented the CCF at the Supreme Court. Thank you both so much for joining me today. Joanna, I'll start with you. What can you tell me about the underlying facts in this case? And while I'll note that the underlying facts and the alleged crimes are not really part of what the Supreme Court was considering, it's important context for our viewers.
Yeah, so very briefly, McGregor was a corporal with the armed forces. He was stationed at the Canadian Embassy in Washington. And in 2017, a member of the Canadian Armed Forces, a woman, discovered a recording device at her home in Virginia. And so an investigation by the Canadian Forces was commenced, and McGregor was suspected. So the armed forces worked with, or rather the forces investigation services worked with local police. They got a U.S. search warrant. That will be important for McGregor's home. They searched his home. They found a laptop, a computer hard drive, and those devices contained, as you mentioned, disturbing recordings, which allegedly were made by McGregor. They showed two different victims engaged in various intimate acts. And so what was inferred was that McGregor allegedly installed hidden recording devices in one case in an individual's home, including her bedroom and her bathroom.
Really, really disturbing what they found. And we can't forget that the victims in this case, there's a publication and ban in place, but these are the reported facts and we need to keep them in mind. Now, Jesse, is there anything to add about why the CCF was an intervener in this case? Was CCF arguing in support of McGregor, against McGregor, or sort of for something else entirely?
So the CCF was intervening in this case, not necessarily to take a side on the merits, but primarily to address the legal questions that were at issue in the courts below and before the Supreme Court of Canada. So the case involved the precedent from 2007, R versus Hape, which is a decision from the Supreme Court of Canada that essentially held that as a general rule, the Charter does not apply abroad, subject to narrow exceptions. And one of those exceptions is if the host state, so here the United States, consents to the application of the Charter. So the real question at the heart of this appeal is really a fact situation that could apply in many cases. So the CCF's goal was really to provide assistance to the court on the legal issue of whether the Charter applies abroad as a matter of course or not, and then how that framework should be applied going forward.
So Jesse, the main question here, when the Charter applies outside of Canada, can you explain why this should matter to Canadians?
Well, it matters because Canadians ultimately deserve to know that when they're abroad, they won't be subject to arbitrary actions by the Canadian government or its officials. So in 1982, of course, when we adopted the Charter, Canada made a choice in adopting those rights to subject Parliament and the executive to constraints, constitutional constraints. And of course, we say, and we'll get into this, while the Charter analysis has to account for the executive's ability to act abroad in contexts like this, it would fundamentally be inconsistent with the choice that was made in 1982 to say that the executive is completely immune from scrutiny by the courts. And in our view, Section 32 of the Charter, which is the Charter that the section that speaks to the applicability of the Charter, is really clear in this regard.
Joanna, we've got to go to commercial break, but when we come back, I want to ask you the same question. How do you think the case is relevant to Canadians? I don't want to be too high level here because I think this really matters, and we need a good explanation of why. We'll be right back. Welcome back to Canadian Justice, where we're discussing a recent Supreme Court hearing where the court considered the question of when and how the Charter applies outside of Canada's borders. Now, Joanna, Jesse answered this question in the last segment, but I wanted to give you a chance to give your input. How does this question about applying the Charter outside Canada, how is it relevant to Canadians? How is it relevant to all of us?
Well, Canada, of course, is a global country, and we know that our government, our executive, our military, they're involved in action across the world. And I don't think Canadians would consent to our executive branch being able to just escape their charter obligations just because they've crossed Canadian borders. And this type of lack of constraint is incompatible with the principle of the rule of law. And just the idea that the executive could be immune from the charter really diminishes, in our opinion, the rights and freedoms of every Canadian.
Now, Joanna, when you talk about the executive, the Canadian executive acting abroad, who would that include? Just so our viewers have a sense of what we're talking about exactly.
Politicians, cabinet members, the prime minister, Chrystia Freeland, even MPs, all Canadian government officials acting in their capacity as Canadian government officials. And
so, Jesse, anything to add to that?
Well, I would say that it also includes, of course, the police, right? So in this case, the RCMP, this case happens to be, the McGregor case happens to be a military case, but it can really apply to any police operating abroad and in any situation that concerns Canadian citizens.
So, Jesse, I want to ask what the existing law is on this, because there is some existing law, but it seems to be a bit of a patchwork. What can you tell us about what principles currently exist? I mean, could, under the existing law, Canadian officials torture somebody outside of Canada? Surely there's already some type of limit on that, but what are the limits exactly under the existing law?
So under the existing law, it's sort of unclear. And so the general rule that's set by the Supreme Court in 2007 is that as a matter of course, the Charter does not apply abroad, subject to two exceptions, essentially. The first exception is if the state at issue, so here, as I say, the United States, consents to the application. And in later cases, the court has created an exception for violations of international law and fundamental human rights. But what's unclear about this framework is that we know that the Charter is the means by which, in 1982, Canada implemented its international law obligations. So the current framework tells us that, in principle, the Charter does not apply abroad, but then in subsequent cases, the court tells us it might in some cases, but it's sort of unclear in what circumstances it would. And more importantly, in the Hape decision, the court relied on a rule of international law that doesn't exist to interpret Section 32. And so there's really conflicting lines of cases, incoherence in the framework, and which is a primary reason why the CCF intervened in this case.
Joanna, is there anything you want to add about what the existing law is and the type of uncertainty it's created and what the problem with that is?
Yeah, well, I would just mention what the actual facts were of Hape to kind of bring it alive. So Hape was a Canadian businessman, and he had an investment business in Turks and Caicos. He was suspected of money laundering, and so the RCMP decided to conduct a search in Turks and Caicos in conjunction with local authorities, but they were sort of in charge. And it turned out later they didn't have a warrant. So the question was, could that evidence be admissible, given that in Canada, you could never get evidence admitted in a criminal prosecution where there wasn't a warrant? And so I think a lot of people really took notice that the Supreme Court of Canada said, actually, the Charter doesn't apply to the RCMP's activities abroad.
So, Jesse, we've only got a minute left, but how would the current rule apply in countries that have very weak institutions or weak civil rights protections?
Right. So we suggest, and we'll be able to get into this a little bit more, but in our framework, we suggest that what the court can do is give the executive a margin of appreciation. So give them some wiggle room, some room to maneuver abroad. So in a situation, for example, where there's no system to get a warrant, what the court can do is develop a framework to say, maybe you need reasonable and probable grounds to search.
Right,
You need to take notes when you're doing the search so that post facto, right after the fact, you can go before a court and they can review that conduct. And the court has done that in various cases. The Fearon case is an example domestically.
Jesse, we've got to go to commercial break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a recent Supreme Court of Canada hearing that considered the question of when the Charter applies outside of Canada. So, Jesse, you represented the CCF in this case, and you've proposed a new test for when the Charter applies outside of Canada's borders. So, can you explain what the test is?
Yeah, so we propose that the court essentially recognize that the Charter applies to the executive generally without geographical constraint, but that the concerns that are expressed in its jurisprudence, that those are relevant in assessing Charter compliance. Sometimes within the rights, so Section 8, for example, says a reasonable search and seizure, or Section 1 of the Charter, which provides for limits in a free and democratic society. So the three-part test essentially is: one, are they acting pursuant to valid laws or procedures? Second, if that's the case, is the conduct of Canadian officials substantively different from the principles that emanate from the Charter on Canadian soil? And third, if there is a substantive difference, is that difference reasonable or justified in the circumstances? So it's when undertaking that third step of the test that we say that that's where the court can give the executive some room to maneuver. And we're proposing that it essentially adopt something called the shock the conscience standard. So that if the conduct of Canadian officials abroad is generally consistent with the norms of democratic societies around the world, that will be justified in that instance. But where it's conduct like torture or other circumstances that most democracies don't permit, that then the courts have a role and should intervene.
So, Jesse, to apply that test to the current facts in McGregor, which involved a search of his home where diplomatic immunity applied to his home had been partially, he argues, partially waived by the embassy, but the waiver didn't include a waiver to search electronic devices. This is McGregor's argument. So he says under the Charter, this was an unreasonable search. Would that shock the conscience of Canadians? How would the test you're proposing apply to the facts in McGregor?
Right. So in McGregor, as you say, the first issue is this question of diplomatic immunity. Did Canada waive diplomatic immunity, and was that waiver sufficient? So we say that question goes to whether or not the Canadian officials are acting pursuant to valid laws or procedures. So the court has to decide that question, and we don't take a position on that issue, but the parties did debate this. On the second question of whether or not it's inconsistent with the Charter, there are conflicting decisions in the courts below. So the trial judge appeared to take the view that it was inconsistent with the Supreme Court's precedent. The Court of Appeal appeared to disagree and say, actually, this method of proceeding, the warrant that was obtained was sufficiently clear. The search was conducted in a manner consistent with the Charter. So even if the Charter applied here, there really is nothing to see here. But we say to the court, if you agree with what seems to be the trial judge's position, and you get to the third step, you still have to determine whether it shocks the conscience. In my view, this case probably doesn't rise to that level because, as I say, we have a warrant, then we have a second warrant in Canada. So the conduct doesn't really seem to rise to that level. And the trial judge actually applied this framework in the alternative in his reasons. So he said, even if I had found that the Charter had applied, I would find no breach here. And so we recommended those reasons to the court. And so we'll see what they do with that.
Great explanation. I guess we'll wait a few months and see what the decision is. And if the court adopts this test that the Canadian Constitution Foundation has proposed. So, Joanna, if the court does adopt this test, how would that create better certainty about Canadian officials operating abroad? We've got about a minute.
I think there's just a lot of confusion about how Canada's human rights obligations sort of coexist with this rule about the Charter not applying. Here we have a clear principle in the Constitution. Executive action is subject to the Charter presumptively, and there's no man's land, basically.
Yeah, so, I mean, currently the law is just this patchwork, as Jesse explained. When we've got to go to commercial, but when we come back, I want to talk about the idea of overruling the 2007 decision, which is a precedent of the Supreme Court of Canada. And there's been a big debate in the legal community recently, especially after a leaked decision from the US Supreme Court about what it means to overturn a precedent. It's an interesting debate. We're going to get into it in the next segment. We will be right back. Welcome back to Canadian Justice, where we're discussing a recent Supreme Court hearing called McGregor and the Queen, where the question of when the Charter applies outside of Canada was considered. And this case, as we've discussed, is revisiting a decision from 2007. And 2007 isn't that long ago, and there's been a lot of talk from pundits in the legal community lately talk about the dangers of overturning precedents, of the role of stare decisis. This has sort of arisen since news from the that the U.S. Supreme Court is going to be overturning a 50-year-old precedent in Roe and Wade. So, Jesse, how do Canada's courts look at changing precedents, including quite recent precedents like a 2007 precedent, and how do you respond to that concern?
Yeah, so I think the court is generally quite cautious, and of course, its precedents deserve respect as a matter of course. But in a recent decision in Canada versus Vavilov, which is an administrative law case, the court had an opportunity to sort of speak to this question of what we call horizontal stare decisis. That is, when the Supreme Court can itself revisit its own precedents. And it said that as a general rule, following a past precedent will further the values that underlie the doctrine. So clarity, predictability in the law, but that when those values are undermined, right, by continuing to adhere to the precedent, that it would justify overturning or revisiting a precedent. And so our view is that is met here for a number of reasons. So first, as I mentioned earlier, the Hape decision is based on a rule of international law that doesn't exist, right? So the case was decided based on a legal rule that just doesn't apply and has no grounding in international law. So that's a huge part of it. The second part of it, of course, is that there's been a patchwork of exceptions adopted after the Hape decision, which sort of eat away at the decision itself and undermine the text and the structure of the Constitution. So, for example, we cite this in our factum, but the international human rights exception, I think what the court meant to say is to talk about extreme cases, but that's not clear. And to the extent that exception refers to international standards that Canada did not constitutionalize in 1982, it appears to permit constitutional amendments without provincial consent, which of course is highly problematic. So we say that the framework is based on a rule that doesn't exist, is slightly incoherent, and so it eats away at that clarity, that predictability, those values that underlie the doctrine of stare decisis. And so in this case, we say it justifies overturning the precedent based on the Supreme Court's own reasoning in Vavilov.
Really interesting. Joanna, same question to you. We've got about a minute and a half. What do you want to say about the role of precedent, of stare decisis, and of the idea of the Supreme Court in this case overturning or changing a quite recent precedent, which we as an organization are asking the Supreme Court to do?
Yeah, so none of these comments should be taken to be commenting at all on the US situation. Obviously, we think stare decisis is important. Predictability and clarity, as Jesse mentioned, are important for the rule of law. However, the Supreme Court of Canada is an apex court, and part of its institutional role is to resolve cases or tests or rules that have proven out in sort of the real world, where people are actually getting charged and investigated and criminal trials are happening, where the lower courts are responding, are communicating to the Supreme Court, there's a problem, there's a lot of inconsistency and everybody is confused, then the Supreme Court, as Jesse mentioned, actually serves the underlying rationale for stare decisis of clarity and predictability by clarifying the law. And if that involves overturning a 10-year-old or 15-year-old precedent, then so be it. So I think that it can be justified in exceptional circumstances.
Well, I guess we'll wait and see and find out the result of the decision in about 6 months from now. Joanna Barron from the Canadian Constitution Foundation, Jesse Hartery from McCarthy Tétrault, thank you both so much for coming on today. We've heard today about a recent Supreme Court case that my charity, the Canadian Constitution Foundation, has been involved in. The question of whether Canada's charter applies to Canadian government action abroad is an important one. We wouldn't want to condone our officials torturing people just because they did it outside of Canada. But what is the limit on government official conduct? What do you think of our proposed test? You be the judge. I'm Christine Van Gyn. Thanks for watching. And remember, a freer Canada starts with you.